everybody, thanks for joining us here today. I'm very excited to be part of this event and being joined by the three esteemed, wonderful panelists. And how I will kick things off, and it's an honor actually to kick things off with the first panel here, is to give you a quick overview on what we have agreed or hope to cover here today, which is quite a wide range of topics. First of all, we like to take a closer look at what sovereign control means. Defining sovereign, one has to be sometimes a little bit careful, but we will take a closer look at it in terms of control over data, metadata, or also derived models. And then we will take a closer look at how do you balance now innovation and regulation, because I personally, I wrote an op-ed some time ago because it's a topic I always felt very strongly about. How do you innovate and regulate, and then while looking also at other jurisdictions, can we learn from them? How have they done it? So innovation doesn't get stifled by regulation, but there have to be guardrails in place. So this is going to be, I think, also a very interesting discussion. We then move also, I mentioned international comparisons before we move into a topic of maybe looking at the EU or the US, what have they done well, maybe not so well. A lot of discussions I recall over the past years in terms of the EU AI Act and just some challenges as well, which the EU had many discussions with some EU representatives have recognized and realized themselves. And then very importantly, we will have a closer look as well at equity and bias. I mean, that's really a conversation in terms of if you think about equity, inclusion, and diversity, algorithmic bias, but also bias within when you develop products, when you deploy products, and when you look at the end user. And there's some great research that was done here as representatives on the panel. So I let each panelist introduce themselves and maybe tell us just briefly why you find the topic we're discussing today of great importance, why you're here and what you wish to contribute, and actually help Franke and her wonderful organization to feed into the consultation that was mentioned earlier. So Emily, may I start with you?
Hi, everybody. My name is Emily Laidlaw. I am a Canada Research Chair in Cybersecurity Law at the University of Calgary. I am a law professor there, and I'm also a board member of the Canadian Internet Society. So I'm thrilled to be here because I think, well, for a variety of reasons, the questions about digital sovereignty for Canadians and how to address the opportunities and challenges presented by AI are coming at a key moment in time for Canada. And I come at it from the legal perspective. So the question for me is, how do you actually create a legal and governance environment that supports the kind of innovation that you want, but at the same time ensures accountable AI, ensures that we're building out trustworthy AI. And that forces us to look in many directions. It forces us to look in the direction of who geopolitically we want to be partnering with. What are the values that we want to align with these different jurisdictions? And how do you build that out into concrete rules? I mean, one of the things that businesses benefit from is certainty. And providing certainty of rules so they know the name of the game and the environment that they're in is key to that kind of success. I think we're going to continue talking about digital sovereignty, but maybe I will just pause there before digging deep into other aspects as we continue.
Yeah, thanks, Emily. Wendy.
My name's Wendy Cukier, and I'm a professor of entrepreneurship and innovation at the Ted Rogers School of Management, Toronto Metropolitan University. I shifted to entrepreneurship and strategy after many years as an IT professor because during my stint as the Vice President of Research and Innovation, I stepped out of the industry for 5 years. And when I looked at stepping back in, I realized my students knew way more than I was ever going to know. And entrepreneurship innovation doesn't change that much. So this is where I ended up. But I started my career working at the Ministry of Transportation and Communications when it was the Ministry of Transportation and Communications. And so while most of my career has been spent looking at technology adoption, entrepreneurship, and so on, I remember very clearly the debates when I started my job about long-distance competition. Anybody here old enough to remember that? Anyone here old enough to remember the interconnection debates? Like, you used to have to get the phone from Bell Canada, and you had to pay more if you wanted a pink phone, but you couldn't plug in a phone that you bought anywhere else, right? And so I started my career in the industry when there was really tight regulation, and I lived through the issuing of the wireless. I was working as a consultant when the wireless competition was decided, and so on and so forth. So I have kind of a mixed view in the sense that I have seen what happens when you deregulate and how that can really drive innovation, entrepreneurship, economic growth, et cetera, But I've also seen the challenges when you deregulate across sectors. You know, it used to be that public convenience and necessity shaped everything from bus service to telecommunications. And there was a huge focus on equity and access, even back before most of you were born. And so I'm really interested in the conversation because I work with a lot of small, medium enterprises. My team's about 80 full-time staff, and we lead research for the Future Skills Center, for the Women Entrepreneurship Knowledge Hub, a number of other big projects. And one of the things that really concerns me is what I label the AI paradox. So Canada leads in technology development, and you know, Geoffrey Hinton was a co-recipient of the Nobel Prize. But by almost any standard, we lag in the adoption of technology. Now, why is that? Well, part of it is, and people forget this, and certainly a lot of the policymakers overlook this, we are a country of small, medium enterprises, right? 90% of employment in this country is with SMEs. Only 50% is in the United States. And small, medium enterprises do not have the capacity, the know-how, the skills, or the time, especially in this environment, to think about doing things because they're struggling to survive. So I'm really interested in this discussion because I think the regulatory frameworks that we establish are going to be key in terms of protecting Canadians and at the same time driving innovation, but also serving the public interest. And I think that's the third leg of the stool that often gets overlooked in these debates, where it's seen as a tension between sort of individual ownership of our data versus corporate profits. And I think we have to think about the public interest and Canada's interest at this particular moment in time.
Thank you so much, Wendy. And last but not least, Elnaz, please.
Thank you. Yes. Good afternoon, everyone. Thank you so much for having me here. This is great to be part of such a great panel. So thank you so much for having me. My name is Elnaz Kanani, and I'm a partner with Artificial Intelligence Practice with Deloitte Canada. And also I'm an adjunct professor at the University of Ottawa, Telfair School of Management. The work that I do is slightly different in a sense that I work exclusively with the Government of Canada, and the idea is how can we bring this theory into practice? The topic of AI, having this in practice, making sure that people can actually use this technology in a safe and secure way, that is the problem I'm dealing with on a daily basis. The reason I'm specifically interested in this topic is that I'm personally very passionate about the topic of AI. My background is mathematics. I used to be the data scientist who would sit and code and enjoy that. And now I'm trying to make this like a larger program, a big solution that can make a change for this country. And I can see the capability because like I said, I've been the one coding these solutions. I've been the one sitting somewhere and building an algorithm and working on that. So I can see what a value this technology can bring to the table and what an impact it can make. And then I hear all of these concerns, and suddenly all of this great technology and concepts and algorithms that are changing on a daily basis suddenly becomes a threat. And that is the moment that I feel like, what can we do to make people understand that, yes, I'm not saying that this threat is not real. We are dealing with a very complex environment right now, but at the same time, being smart, we can consider that threat, keep that in mind, and then also make an improvement in the way that we work with the technology, with the right tool, in the right environment, and all that. So I am a big believer that knowing the problem is the main step to solving the problem, and that's why I'm specifically passionate about this topic.
Great. I mean, first of all, what a variety of perspectives and backgrounds. This is the benefit of having such a diverse panel. I mean, really compliments, Franka, for putting it together. It's just really fascinating. Well, then let's dive into our first question. Whether Wendy or Emily want to start there maybe first, it's about sovereignty that I think, Emily, you also said, yes, it's definitely a topic we will be discussing a little more, and sovereign control. And what does that exactly mean if I try to define it in terms of sovereign control over data, metadata, and so forth? And what does it mean for the Canadian public and private institutions, maybe legally and also operationally? I mean, there's a lot in that question. You please, whatever you feel comfortable with or whatever your thoughts are on this. Who would like to kick it off, whether Wendy or Emily? Okay, Wendy. Sorry, Emily. Yes, you just, okay, you go ahead, please.
I mean, it is the question, isn't it? You know, we've tossed out this term as though we know what it means. But at its core, sovereignty is really about the agency of Canada. And I mean this all in terms of both the public and the private sector, individuals and government, having the agency to make decisions about its own digital future. And so I think, you know, everyone in this room probably has ideas and maybe what the core components are that form that agency. And I don't have all the answers to that. So I'll tell you the top ones that come of mind to me is one is facilitating the innovation culture, which I think that we all know, and that's why we're seeing the investments we're seeing in kind of Canadian homegrown and made businesses, but also ensuring that we're training the talent at a university level, that there are opportunities when they come out, that there is an environment that they want to stay in. And Wendy, I might just kick that more to you when it gets to you, because I imagine this is much more in your wheelhouse than mine. The other aspect to this is building a governance and regulatory framework that is coherent. I will say that at this moment, Canada does not offer that. And there have been numerous attempts at digital policy. And we saw that with, if we could create a Venn diagram, it would solve all things right now, because what we see is some key overlapping areas of law that are all important here. One is sort of the domain of private sector privacy and cybersecurity and what needs to apply there. The other would be this sort of AI regulation, whether Canada passes that or not. And then you have competition law and the possibility of online harms, because we can't forget that we're seeing a huge uptick now of AI facilitated harms, whether we're looking at, you know, the examples I've been giving lately are about, you know, the chat GPT pushing suicide content to children, prompting psychotic breaks, character.ai becoming immersive and kind of developing sexual relationship with a child who then took his life. So AI facilitated harms here are enormous and it's opaque. But if we don't have all of those laws in Canada, but they all overlap. And so there needs to be much stronger conversation about what regulatory coherence looks like domestically, so that we have meaningful regulation that isn't just performative on the part of companies and weighs them down with box ticking and things to do, especially in an environment of SMEs. But also we have to look across the pond. If we're wanting to align ourselves with the EU, there are values there that have been established through their Digital Services Act, Digital Markets Act, and so on, that Canada needs to look at how we don't have to necessarily align, but how we can build a coherent framework that would fit with the EU. And I acknowledge that we are in an interesting times given our relationship with the United States as well, but policy choices need to be made about how to create that coherent framework. And I'll end with maybe one final point, and that is, one of the ways that I think that coherence can also be built out is that there's tremendous expertise in this area across Canada, and we need to be bringing them into the room to advise the government. I mean, if I had to wave a magic wand, I would suggest that they create some sort of expert kind of policy advisory body on digital issues that were across the ecosystem of these different areas, because they are connected. And without that kind of feedback and iterative feedback, then there isn't going to be the awareness of between these different silos.
Yeah, thank you so much. Especially, you just reminded me of all the bills out there, or that used to be out there. If you think about the previous, well, C27, that's right. But you have also C26, now C8. Then you have Bill C2, look at parts 14 and 15, the Online Harms Act, which was C63. You're absolutely, there is that coherent element that you mentioned, and there are probably many more that we have the pleasure of probably engaging with in the near future. I leave it whether Wendy or Elnaz, is there anything you wish to add to this topic?
I'm so conflicted about this, because on the one hand I'm just fascinated, and on the other hand I am absolutely terrified. And to me, you know, I don't know who said it, but recently someone said Canada needs to be a lot more concerned about sovereignty, because the world has changed and we now live with a neighbor who's both capricious and dangerous. And I remember when the Patriot Act came in, a lot of my colleagues were very concerned about the fact that university was going Google. And I was like a conspiracy theorist, whatever. Anybody here scrub their phones before they go south of the border now? You know, it's a clear and present danger from my perspective, not having appropriate protection and sovereignty of our data, our infrastructure, and so on. At the same time, I'm old enough to remember, you know, I was leading something called the Northeastern Ontario Telehealth Network many years ago, and it was just when Macs were coming in, and we were using Macs in the office. But the government of Ontario, in its wisdom, decided that we needed a Canadian-built personal computer. Anybody remember the icon? Right? And so we put a bunch of money into developing a Canadian-made computer and forced all of the participants in this provincially funded network to put in icon computers. And guess what? We didn't get very far. So I think we have to recognize that as much as there is incredible Canadian talent and opportunity and amazing Canadian businesses and so on, we can't cut ourselves off from global innovators as well. And what I worry about is that we let the perfect be the enemy of the good enough. And what I keep hearing from businesses, we did a big survey of SMEs, 1,700 of them. A lot of them are stuck because there is no certainty. And the rule of law creates certainty in which organizations can make decisions about investments and innovation and so on. So all I would say, if I knew the minister, is get on with it. You know, don't let the perfect be the enemy of the good enough. And frankly, while I think there are certain things we want to harmonize with the EU over. I think they've gone too far on some of their regulatory frameworks, and I think we need a Canadian compromise, which we always have, between some of the models in the US and some of the models in the EU.
Yeah, thank you. And the term also harmonization or alignment is often a bit tricky. Often we prefer really to look at interoperability and absolutely.
That's why I prefer coherence, actually. It's a little softer, a little less.
Yeah, absolutely.
Cohere.
Yeah, cohere, yes. Yeah, I was just thinking about, there's another great example, great Canadian company. Elnaz, is there anything you wish to add to this?
Just one tiny comment here. As I'm listening to this conversation, and many other conferences these days, talks that we all listen to, podcasts, and unfortunately, we have lots of sources for information these days. There is one tiny problem here, and I mean, one of the problems, let's put it this way, is that I don't think that we are all talking about the same things when we use these words, whether like sovereign, bias, security, residency. I feel like there is like absolutely echoing what Emily and also Wendy mentioned, 100% agreed. We need to act on it. We need to have the right policies in place. But before that, we need to understand what is the problem. I honestly don't think that we are all on the same page in terms of what it means when we're talking about the problems of our data leaving the Canadian border. Like, why is that a problem? Like, have you ever thought about that? Like, why that can be a problem? I mean, what can they do with our data? The data that is probably being hosted by some governmental agency. If you think about it, then when you explore the definition of this problem, then you can see what could be the solution for a problem like this, and whether or not it should be top of the list to address, or maybe the second item on the list.
And you're pointing out a great, very important challenge. I think it's often when we look at certain terminologies that the definition is not quite clear, or it's being interpreted or understood in a different context, even per culture, per jurisdiction, and so forth. Yeah, please, Wendy.
I can be super clear. I don't think foreign governments should have access to Canadians' data, particularly sensitive data, without a court-approved, what do you call it, search warrant, whatever the thing is, from a Canadian source. Like, for me, that is pretty fundamental if you're concerned about keeping Canadians safe. That doesn't mean that we can't collaborate with foreign countries. And there are some models of, creating servers in other countries and so on. But if a foreign government has access, I don't mind my government having access to my information. I love CRA, right? Because that's where the public interest comes into play. I think as Canadians, we say our government can have access to certain information. Our government can make policies and decisions based on having access to our information, and most Canadians accept that. But I get very twitchy when I think about the prospect of foreign governments having access to Canadians' personal information. I don't know if others agree.
So just to add something to what Wendy mentioned, I use that as an example, and intentionally I used a very sensitive example. So I'm not saying that it's not a problem. I was just saying, like, my comment was more on, like, let's think about what are the problems of all of these risks that we're thinking about. Like, just wanted to clarify that that's not what I was referring to.
Yeah, so, and I might jump in here to say 100% agree. We need to talk about definitions. I don't think we're going to land on them. I think that maybe we can identify it. We'll get into this horribly academic exercise of a taxonomy, and maybe it's necessary, but we at least find shared understanding. But something like, you gave that example of that sensitive issue of data crossing borders. And my initial reaction was, of course, this is an enormous issue. but also this has been heavily studied.
Yeah.
We don't have very good solutions to this, but I mean, I look back to the very beginning of internet regulation and internet governance issues, and what was the big question? It was the ability of courts to be able to enforce their judgments against actors that were in other jurisdictions. And we continue to have enormous challenges when it comes to this space. It's why we talk about regulators needing to have stronger powers as the privacy commissioner, why we need to have maybe an online harms regulator that would have the power to fine, and even then, is it going to be just a cost of doing business, et cetera, et cetera. So all of these conversations are the fact that, you know, we're talking about an inability of our country to apply and enforce its own laws within kind of our own borders. And that is deeply concerning. And this is only now amplified when it comes to AI. I am going to talk out of two sides of my mouth here when it comes to AI, because I know, you know, that thing, we need to think deeply about this. We don't know what makes mistakes. My first criticism of the AI Act, which we'll get to, although we're messing with the order of things right now, aren't we, is you know, my first criticism of it was, like many, it came out of nowhere. There wasn't really much consultation. I had some conversations later about it, but it wasn't the kind of extensive conversation that AI regulation has or should have in these circumstances. Now I'm going to talk out of the other side of my mouth is, dear God, do we need this yesterday? As a basic level, we need to have some accountability framework that isn't relying on companies that right now, they are in an arms race to consolidate power. And what we're seeing is that all the decades that it took for some of these platforms to gain power has just been accelerated overnight over the last couple of years, because they already had power and used that power because they're data driven to then gather power as AI companies. That is concerning for Canada because we don't have then that oversight over it, and we want to fuel the innovation economy, also want to protect the rule of law within Canada, and we do face a significant threat without setting the rules of trustworthy AI.
Well, yes, can't agree more with you. And just like one example on like something related, a few days ago I was chatting with someone, a technologist, just to be clear, and I had like a 30-second complete like blank when I heard this. We were talking about the same topic, and one of the things that was mentioned was that we were talking about the fact that whether or not for this specific use case, we can use a data center that is not located in Canada and it's actually Eastern US. So not in Canada, but in North America. And of course, the answer is that no, like we can't. Data should stay in Canada. Sure, of course, that's how it is. And then the next sentence, or like the next few parts of the conversation, was about the fact that, and that's when I completely was kind of like, is this really happening? Was that if we mask the data so that it's not like an individual is not recognizable, then it's okay, it can stay anywhere. So at macro level, we are good. This is scary. That's when I say, like, sometimes I feel like we need to think about what it means that when we're talking about this is a risk, why is this a risk? Because then there is a comment, again, just to be clear, this is not correct. Regardless, personal data should not leave Canadian border. That's not what I'm saying. But what I'm trying to explain is that it is important to understand why this is a risk, not just because I like my government, I don't trust any other governments, but really, like, deeply, what does it mean? So that we can't, like, that statement is like a red or, I don't know, black flag or something like that of, like, how can we say that at macro level we can let data leave the Canadian border and that's fine? No, that's not fine. But it is because it was never well understood for this person who's actually a technologist, that what does it mean for data to leave Canadian border? So that's really what I was referring to. Is kind of like in my head, I was like, no, that's a problem. That is actually a serious problem.
Thank you so much. And I think what's important with that deeper analysis, it will help also with public trust, because the public then also gains a better understanding of, to your point, what is the problem and why, what's the rationale, what is the suggested solution, and something that is explained in simple terms and plain text to everybody. And that, because we talked about also as one of the topics here, public trust and trust per se in the technology. We touched upon, and this is great, this is organic, I like it much more than having all the questions outlined, but we promised earlier to touch a little bit upon innovation and regulation, that balance as well. Perhaps if we just take one closer look at it one more time, and maybe Elnaz, I stay with you, and how can AI teams balance innovation and agility in model development while respecting privacy, sovereignty, and also compliance requirements? And I mean, there a little bit of a thought of the Cloud Act comes as well into play, because if you have using cloud or hybrid infrastructures and influenced by laws like, for example, the Cloud Act, if you wouldn't mind commenting.
Of course, yeah. This is a question for every single organization I'm working with, because we understand that we have a rich data set, technology is advanced. Actually, sometimes it's not very expensive. And we have lots of resources doing some of the repetitive tasks. So can we make it better? That's a typical question. And then always in these scenarios, there is this other person at the table who's kind of like, wait, what do you mean? Like AI, I don't trust data. I don't trust AI. I don't trust this technology and all that, which is a very valid point. So the way we approach this, and I think that this has been very effective across large organizations, and I think that it would work like in smaller, medium-sized organizations as well, is that and I say this like with an air quote, and I truly mean that, to have a proper framework in place. A framework to me is not a nice, good-looking deck that has all the right colors and all the right icons and it's pleasant to read, and still at the end of it be like, okay, what am I doing with it? And people are still struggling to follow like the tactical steps of it. What we have been doing is that we have been recommending and we've been helping different organizations to think of tactical things that they need to do when it comes to innovation using AI. What do I mean by that? Still, I'm not helping. I understand that. So let's think about the case of we need to make sure that this data, like this specific data set, I need to understand that I'm using this for this specific algorithm. This data is classified as whatever level it is, and I need to be careful about it. Just that statement. Think about that. So frameworks like this break down a state or a problem statement like this into steps of, like, for example, classify your data, identify whether and by classify, like in my world it is like protected B, PII, this and that, like the different levels that we have, but for any organization it can apply. So classify your data, understand what is it that you're going to do with your data. For example, is the data collected for example, reporting on something macro? In that case, you cannot use it for something totally different. You need to go and ask for consent. So like step-by-step guideline of, as you're thinking about a use case, what are the steps that you need to follow to make sure that you are on the right path? Here, something else is also happening without us noticing. In the world of data scientists, we love data sets. The more complex, the uglier it is, happier we'll be. I'm not kidding. It's just like a challenge for us. However, the worst thing that can happen to us is that we start working with a data set, we create something, and then someone comes to us and say, oh, you were not allowed to do that. Like, why did you generate this graph? Like, how? Like, where is it sitting? And all those sorts of things. However, it would be awesome if from day one, that was in practice happening in parallel with us. So day one, as I start looking at a use case and asking for data sets that would support that use case, I should have a framework here that says, go look at the classification of the data. That's your first step. Your second step is that what was the purpose of collecting this data? Why was it collected first place? And now, what are you using it for? Are these two, are they the same or not? If not, you need to, you cannot just, here, you need to stop. You need to do something here. So something that as the model development, as the testing, as all these steps we are going through, we can validate each and every single step so that it's not a block afterthought. It's more of a parallel, in parallel activity that we need to keep in mind as we are doing innovation. Someone would argue, last piece here is that, okay, still you're making it difficult for me. And that is correct. You're right. Especially if you think about the younger generation coming out of school excited, they want to put all of this into practice, and then you're going to tell them, oh, no, hold on a second. Why was the data collected? What are you going to do with it? There is this moment that you kind of see that all that motivation is gone for a second. But what we've been seeing right now in actually two of the organizations I'm working with right now is that we are giving different environments for different purposes. You have, for example, a sandbox for innovation. Go explore. And here are the data sets, all the connectors that are good to use. So I'm limiting access to what is allowed to be used for exploration. So you have access to this environment, all of these AI services, and all of these data sets. Go explore, go innovate. But the moment that you want to replicate that in a production-grade environment, we need to follow that framework. So it's something that can happen in parallel. It's not a blockage. It's just that we need to keep in mind that it's not an afterthought. It is a in parallel process.
Can I ask a question? So I have a question for you on just a practical level, achieving that, because I love that. That was fascinating. And in the back of my mind, I was thinking, oh, this very much fits with the kind of privacy by design frameworks that we're talking about it. And in the online harm space, we also talked about it too, that we need to just think about it as the front end. Something that kind of in my world, some of the struggle has been one, what I'll ask you is, who should be in the room together to ensure that it's actually done up front? But second, how do you ensure it's done in a meaningful way and not, because some aspects of privacy impact assessments and so on end up being a box-ticking exercise that a corporation needs to just get through to get on with the work that they want to do. And it is incentivizing the sense of responsibility that comes along with creation and innovation. That is such a tricky piece in all of this. So I'm hoping you can solve all these problems, and then she can just run all of this for us, right?
No, it's a great question, Emily. I appreciate you raising that. I have another scary story. So the other day, I was with one of my amazing clients, going through I want to say deployment, but it's actually pre-deployment. But let's say that we have built a solution and we tested, everything is good. We want to deploy it in production. Everything is good, right? And then we need to go through a process. Exactly to your scenario, exactly that. We need to go through a process. They have I'm not going to use the acronyms because I honestly don't know to what degree it's going to identify the organization, so I'm going to keep it very high level. So let's think of it as a PM-based process, a management. We just want to know who's going to access it, what's the version control, all those sorts of things. Here is the process that we have in our organization. Step by step, you should follow this, and then you can deploy. As simple as that. Makes sense, right? So we started going through it, and then we noticed that, okay, step 4 and 6 and 10 and 25, actually it is just 18-step process. I made that up. But multiple steps in this process are not applicable to the use case we have. So we went back and we were like, okay, you know what, we don't have this thing, so what should I do? On the spot, the person in charge said, that's okay, skip it. And I was like, no, hold on a second, what do you mean? Like, you cannot have a framework and on the spot just decide that it's okay, skip 3 steps. That goes back exactly to your question of who should be in the room and who should really make that decision. In my head, that was kind of like this moment of like, okay, I'm gonna just drop this call and I'm just gonna think about this for another 2 hours, and then maybe I come back and say, let's rethink this whole thing. But like in reality, that's a serious problem, because in their world, what is happening is that someone created a framework without knowing exactly why each step was in place. And then the moment that we said, okay, this doesn't apply, they were like, oh, okay, so it doesn't apply, just skip over it, it's good. As long as you just say that it doesn't apply, we're good. So to your question of who should be in the room, I want to go back to what I said at the beginning, being like that educational or understanding piece. We need to, as people in charge, I think we need to understand what each of these acts, what each of these policies, the whole concept of, you mentioned privacy by design, everyone talks about it, and I'm sure many people or everyone in this room is comfortable with the concept. But like in reality, how many people can say what does it mean in practice? And I 100% am with you, Emily, in what you said. I can't agree more that do we ever get to that point that everyone is on the same page? I don't think so. But at least we need to put an effort to understand Bill C-26. What does it mean in practice? And to me, as a person whose English is not their first language, for me, like reading a bill like that is a nightmare, because many of those words for me are kind of like something that I'm not able to really connect with. But even if English is my first language, I have a feeling that in practice it's not clear. That's why I think that an organization who's creating that framework that I mentioned first should sit and say, this is the policy I'm following. These are, not this. These are the policies we need to be compliant with. In our world, this is what it means to us. And Alex, you're in charge of this. Mary, you're in charge of that, and you are going to be in charge for these things, and like solid, set in the stone.
Thank you so much for the passion on this particular. No, seriously, it's really important. And one, I mean, we mentioned a few times who should be in the room. That brings me, Wendy, maybe to a question that I may raise with you, is the digital divide. Again, who should be in the room? When we prepared for, of course, our panel discussion here, we talked about men versus women, indigenous populations, and so forth. Can you, in this context, I mean, the Diversity Institute has done some amazing research there. Would you be so kind and maybe bring that lens to this conversation?
So, you know, the digital divide operates at multiple levels. Not just the governance level. I mean, historically, people have thought about the digital divide in terms of access to infrastructure, and we know that, for example, in indigenous communities, there are many places still without clean water. They certainly don't have high-speed internet access, and so when you're designing products or services, you have to take into account the fact that you can't assume access to basic infrastructure, but you also can't assume access to skills, knowledge, et cetera, et cetera. So there's the whole piece of data literacy, AI literacy, whatever it is you want to call it. And then the third thing is around affordability. And one of the things we found during COVID, for example, is as everything was shifting to digital, something like 42% of racialized kids in the city of Toronto did not have access to high-speed internet and were doing their homework on iPhones. Because of affordability issues to a large extent. So when we think about the digital divide, the first thing is to think about those fundamental issues around access and participation. You send out a call for consultations on AI policy. Who's going to be in the room? You look at who the advisory committee is, who is going to be in the room. So I think the same thing applies within organizations, and some of the models that have been developed around research ethics, data management in that context may have relevance in this context as well, where in addition to having a framework that looks at levels of access and sensitivity and looks at what the policies and programs are, thinking about who is or is not in the room becomes very important in terms of discussions of the appropriate use of data, because you can get people to sign things. And one of my pet peeves, some folks in government may be part of this, so I apologize. In the quest for data and randomized control trials, for example, some government departments are requiring participants in government-funded programs to share all of their data. And in some communities, particularly those that have been, subject to genocide and all kinds of forms of exclusion, exploitation, and so on, giving up personal data, relationships with big institutions are really problematic. So I think that's a piece of this that often isn't, like, what is consent? And very often what I would observe is we see a lot of coerced consent. We see a lot of people who aren't even in the system because of the access issues. And then the final dimension of this is, of course, when we're developing the systems, all of the issues around bias and how bias gets embedded. So I do think that bringing an equity, diversity, and inclusion lens to this complicates it without question. But if you don't start asking those questions, again, the public interest is not being served.
Yeah, 100%. Is there anything, Elnaz or Emily, you wish to add to this particular topic? And I remember, I've seen you speak many times, Wendy, that this has been an ongoing issue for so many years. And I remember the one call or conversation or talk you gave when we haven't really made much progress, which is pretty sad, unless I do remember this incorrectly.
Well, yes and no. The other thing that's really interesting, we just did a survey twice of 5,000 people with environics. And when you look at AI adoption, guess what? Indigenous peoples, racialized people, and immigrants have higher adoption rates than others. And there is a gap between men and women, but it's much, much smaller than the gap you would see if you ask questions about coding. And why is that? Well, generative AI is kind of the English major's revenge. So it's really undermined the stranglehold that tech grads have typically had on these issues, and it's opened up both opportunities for access, but I think also opportunities for engagement in thinking about our future.
Wendy, you totally broke my heart.
Do we still have a few minutes? 3 minutes. 3 more minutes. Let's see if in that last, because we promised, so I like to keep promises, we wanted to quickly look at the global landscape in terms of legislation, but perhaps in terms of your views on, we used to have the AI Act ADA before. If we look at future AI legislation and what worked and didn't work in the past, are there any recommendations, what amendments should be made to the previous act we had, or how our future AI legislation should look? Is there a jurisdiction for us to follow, or maybe to stay away from, because we also learn from what not to do? Maybe any comments on that for the audience and for, of course, the consultation would be really appreciated. Emily?
I will keep this short given time. So I will say this. Yes, we should reintroduce an AI Act. Fundamentally, they need to make changes to what had been proposed. I don't think that's a surprise. Most thought that. The number one thing I would say is there needs to be an independent body overseeing this. There isn't any universe, and I can imagine that putting some AI commissioner within ICED provides the accountability, independence, and ethics necessary for this quickly evolving space. There also was, AI Act only really focused on high impact systems, and there's such a diversity of AI that wasn't accounted for within the Act, and that nuance needs to be captured. There also might be, and is, some AI that just should be no-go zones, and none of that was accounted for. It treated even the most high-risk AI as being something that you could just risk manage. And the last point I want to make is, guess who it didn't apply to? The public sector. That was just a miss. I mean, maybe it was trying to parallel privacy legislation, have a private one and a public one. But given where we're at, we can't proceed with AI legislation without also capturing government. Last point, Wendy, you said the EU was overly kind of complicated. I don't want to speak for you, but I thought that was a good point. And I would agree, we're seeing the growing pains over there, and also the lack of coherence. And how does the AI Act work with the Digital Services Act, and how do they overlap? And that is exactly the kind of complication that is going to have negative impacts on companies. So I think a made in Canada version that maybe has the same basic framework is the ideal solution going forward.
Thank you, Wendy. Anything? And I know you spoke about SMEs before as well. How do they fit into that whole framework?
Yeah, I think I would just echo what just was said. And I personally, and there may be exceptions, but in terms of no-go zones, I was at a conference where they were talking about autonomous weapons, for example. There are some really, that's why I said I'm fascinated, and I am also horrified, particularly during, in the current environment. That being said, I mean, one of the opportunities we have is with the big investments in defense, what was the Israel miracle in terms of entrepreneurship? It was the investments to a large extent in defense. And we do have some opportunities around dual purpose technologies and so on and so forth. But I think the no-go zones, like, we absolutely need to get some consensus around that. And the only other thing that has been flagged is making sure that we separate out things like certain digital harms don't belong in the AI legislation. They belong in the criminal code, and let's just deal with them there, because we're likely to get four-party consensus on moving some of that stuff through.
Perfect. Thank you. Great feedback. Elnaz.
Very quickly, because I know we're at time. The only thing I would add to what was mentioned is actually a very lower level of analysis when it comes to this topic, and that is about architecture, about MLOps processes, about model lifecycle management. Usually when we're talking about policy, compliance, all those sorts of things, the first thing that comes to my mind, to everyone's mind, is operating model, strategy, privacy, very important topics, but usually these tiny yet important topics just fall off that list of how as a country we should think about data architecture. And this is particularly important because the last thing we want to do as a country is to do something, invest all this money, and then 3 years from today have to just wipe it off and restart the whole thing. That is a loss, and we don't want to do that. We need strategy and structure around data architecture, about MLOps, about our model management, and all those sorts of things, so that as different organizations, we can talk to each other. Because otherwise, what's the value of this technology? Okay, it's going to be better in my tiny world, but how can I advance that? The reality is that scaling AI is not, and I keep saying this, scaling AI is not about having more models, more solutions. No, it's not that. It's about scaling that trust that people are open to using it. It's that adoption.
No, you just triggered a thought, which is I think we have to really differentiate between what should be in legislation, which takes a long time to get in place, what should be in regulation, what should be in standards. Some of you probably lived through the development of the OSI models and so on, and it seems, and what should be in voluntary codes. I'm a big fan, frankly, of the Hiroshima process. It contains a lot of the same stuff as other guidelines for responsible AI, but I think calling it Hiroshima reminds us of the risks of technology gone awry. And so I think that's, I think we need to really be clear about what belongs in law, what belongs in regulation that can be readily changed. Where are we looking at standards, and where are we looking at voluntary codes and principles, and what are the guidelines for implementation? And we can't mix those up.
Well, thank you.